the inapplicability of a pre-termination hearing or anything else like that prior to the settlement is essentially being considered as bad faith by the city. That was clarified after a federal court case in the settlement.
So basically, you're saying we don't have to bring out Loudermill or anything.
Loudermill, yeah, the fact,
That's
the lack of
I don't
Loudermill,
think we're going
right.
to get into the technical aspect of that anyway.
Right.
So thank you. Does Chair have any comments on that?
Yeah, understood.
And just to make sure, so you know, we can talk about the content of any meetings that Chief Rodwell had with Commander Minor, but they are not asserting any issue for this hearing about the fact that there was an initial termination decision that was rescinded.
Right.
Oh, okay. No, yeah, I think the Vice Chair understands that. I think I do. So
Okay. Thank you.
Thank you.
Ms. Cronin, I do have a much narrower question about due process. There has been an allegation in this case that the investigation of Commander Minor did not comport to due process because its result was predetermined. Did you review the actions of the internal affairs investigators to find out whether they were neutral or whether they had a predetermined result going in?
And I assume you're referring to 085?
Correct.
Well, that was part of it because I discussed with Lewis particularly, really with both of them, but Lewis was the key investigator with regard to what happened, how he conducted 085. And he went through, and obviously he said, we interviewed Commander Minor and he described to me how the interview went. And then he said during that interview, he found for the first time that Commander Minor had gone to POP. And he wasn't even aware that had even occurred until this investigation was conducted in October. And so he said, so I decided to interview POP to find out, in fact, what had occurred, what was said, so on and so forth. From what I saw and what I discussed with Lewis, as I recall, he gave Commander Minor proper notice as required under the Bill of Rights. I believe he was allowed to have a representative there. I can't recall if he did or not. He was given an opportunity to provide a statement at the end of the interview. The Bill of Rights, as I recall, says that it's a max of 5 minutes. Lewis said it went on for about 17 minutes. I think it was a PowerPoint presentation, which, as I recall, is included in the investigation. And never did I find that Lewis went in there with the idea, well, Minor lied and I'm going to prove he lied. It was, tell me, he was trying to find out, like everybody was, to get an explanation as to why Commander Minor answered the way he did. And he said, you know, he ultimately said it just really made no sense because he contradicted himself. He told me about all these, this meeting and discussions he had with Bonnet. They were pretty detailed and lengthy, and he never told me that in the first interview. And if he had, I would have interviewed Bonnet immediately.
Is there any doubt in your mind that the city's policy required Commander Minor to bring that information up to investigators in that first interview?
There's no doubt, because the policy is very clear that you need to be truthful and complete, or at least truthful. And there was so much there that he didn't share with Lewis in that first interview. Even if he had just said something, I think, along the lines of, boy, it's not my story to tell, but you need to talk to Bonnet. And he didn't do that. And the other problem is when he reported to POP, which Lewis found out in October, or September, I think it was October, that not only did he report that to POP that Bonnet had been offended by the comment, that he reported that he also was offended. And yet, when Lewis interviews him approximately a little more than a month later, in the first interview, he never discloses that he was offended by it. He just said, oh, I think it was his attempt at a bad joke.
And to clarify, your impression of Commander Minor's statement in the first interview was that even though the comment would be objectively offended, he denied any subjective feeling of offense.
Right.
And was that a material difference to you?
Yes.
One of the themes that has been developing in this case is there has been challenge to Chief Rodwell's handling of the assigning of the IA investigations. Specifically, he's been faulted for not sharing all the information that he did or didn't have with IA before they started their interview. Do you think that is a valid criticism? Can you talk about that?
Well, I'm not sure what that information is, but I will tell you, my experience has always been is that dealing with police departments who handle these is they give the investigation to the IA and they don't give them a pre-background because they want to keep it independent and keep it, they don't want to set the tone, if you will. So I'm not so sure what Rodwell should have shared that he didn't share. I mean, I don't think it was necessary for him to go into all the discussions he had with POSA and I think the ASCOPs. I think it was basically let Lewis do the investigation based on the letter that they received from POSA and let the chips fall where they may.
And we'll hear witness testimony and the witnesses can speak for themselves, but I don't think it's been established and there's a difference between whether Chief Rodwell knew that Commander Minor had gone to POP after the Slater comments, or that Commander Minor had shared the information about Lieutenant Bonnet with POP. So regardless, assuming that Chief Rodwell did know about all of these conversations, would it have been inappropriate for Chief Rodwell not to share that background with IA?
Right, because I think, again, that goes to now Rodwell's trying to manipulate, an argument could be made, that he's trying to manipulate and set the tone for the IA. Instead of just letting Lewis, with a clean slate, with the letter of complaint, which was from POSA, go and investigate those allegations.
And the clean slate is a better practice, is it not?
Yes.
Do you think it excuses Commander Minor for his answers in the first interview, for him to have told POP about Lieutenant Bonnet beforehand?
No, I think Minor, in my opinion, did the right thing by reporting it to POP, and in fact, it would have been remiss on his part had he not done so. So I think he acted very appropriately. Where the problem lies is his response in IA.
It would be unreasonable for Commander Minor, especially as a former IA investigator himself, to just assume that IA would know about his other conversations if he didn't tell them.
Exactly, and as part of his responsibilities, he's to provide what he knows, and had he done so, Lewis would have discovered all of the information that allegedly Chief Rodwell had, because he would have found out that that the information had been reported to POP, that Bonnet was offended, and arguably that even Minor had alleged that he was offended. So all of that would have come out.
You mentioned an interesting issue that Commander Minor may have been remiss if he didn't go to POP. My understanding of the sequence of events is that the day after the meeting, Chief Slayton sent an email to everyone at the meeting apologizing and acknowledging that he had engaged in unprofessional conduct.
Yes.
And the email recipients were able to see that Chief Rodwell was copied on that email. Given that, do you think that there was any further obligation for other people in the meeting to have also gone to their supervisors?
Well, how it works is if the supervisor is aware that somebody in their chain of command feels they've been discriminated against, or they've been treated in an unprofessional manner, they have a duty to report that information. Minor, or excuse me, Commander Minor acted appropriately. I'm not aware, and if anybody else in that meeting had similar information, they would have an obligation to report as well. I'm not aware from the interviews that were conducted of the people in that meeting that anybody fell within that same, that had the same situation that Commander Minor had, where a subordinate employee had come to him and said, this, upsets me.
So it's a key difference for you, the fact that it wasn't just offense, there was an employment and supervisory aspect to what Commander Minor knew, because Bonnet was his direct report and he was sharing that information on his chain.
Right, he would have had, if he had not reported that to Pop, that would have been inappropriate, and that would have been a violation, because as a supervisor, you're obligated to do so. Now, my understanding there were colleagues in the meeting that were on the same level. Well, no, actually, they were subordinate to Slavin. Do they have a duty to report it? Well, that's where it gets muddy, because, and this just happens when you're in a meeting that size. You get a lot of sidebar conversations, people aren't paying attention. Plus, there was confusion about, some people thought Charlie Hebdo was a general, some people understood it was a newspaper, so everybody had different impressions, and I think some of them weren't even listening to the discussion.
Okay. So everyone in that meeting knew that Chief Rodbell had been informed of the existence of at least one unprofessional comment.
Right, clearly because it was copied on the email, but I don't think they knew how that email came about, and there was no reason why they would.
Okay. And in your review of the records, you did not see anyone else in a similar situation as Commander Minor who had employment and supervisory obligations to report?
Yes, with regard to his subordinate Bonnet.
One of the issues in this case has been the number of times that Chief Slavin was interviewed by IA, 3 altogether. Are you familiar with that?
Yes, are we counting the first investigation as well, or just
Yes.
these? Okay, yes.
Just to clean it up, Chief Slavin was interviewed 3 times over the substance of his comments on the question. Is that right?
I recall 2 times he was interviewed based on the substance of his comments. Is it 3 times? Okay, if it's 3, that's fine. It was more than once.
Okay. And we did have some testimony yesterday where the investigators acknowledged they should have asked him about 2 comments at the beginning, and that when notified or when it was brought to their attention, they went back to try to fix that mistake. I'm sure in your history of investigating people, you see that people do make mistakes. Is that right?
Yes.
In your opinion, when any mistakes were brought to the attention of anyone throughout the leadership of the city of Scottsdale, did the city or the department or Chief Rodbell take action to fix those mistakes?
With regard to these investigations or just in general?
With regards to these?
Yes. I know at one point when Commander Minor made allegations that other people were dishonest or disingenuous about what had occurred at that meeting, Chief Rodbell ordered Lewis and Gollihar to go back and review everybody's comments to see if somebody else had not been truthful.
There's been criticism in this case of the internal affairs investigators for not opening an investigation or referring an investigation, for Chief Slavin for an integrity violation, for not talking about the second comment in his first interview.
Right.
Do you believe that to be a valid criticism, and can you discuss that?
Yes. No, because Slavin is the target of the investigation. And so you answer the questions that are asked of you. You know, it's the old adage, don't volunteer information. It's just like when a defendant is testifying in a criminal case. Answer the question that is asked of you. Do not volunteer. And Slavin was answering the question that was asked of him. Now, don't be dishonest in your answering the questions that are asked of you. I mean, you have to be truthful, but don't volunteer information. He's in a different category than, for example, Commander Minor was, because Commander Minor was not the target of that internal investigation. And I'm talking about 048, not 085.
And we've talked about in the case already whether there's a specific written policy that explicitly says if you're the target, you do not have to volunteer information. However, there's also a practice and an understanding in the city.
Yeah, there's nothing that says that specifically in their general orders, but it's just an understanding. And I would say it's not even limited to the city.
Is that an understanding that has applied in every internal affairs investigation you've reviewed?
Yes,
Not just in your case, in your career?
right, yes.
And that's a standard that you feel has been evenly applied?
From what I understand, yes. And, well,
Right.
yes.
If you have more to add, I'd be glad to hear it.
Now, I just would add though too, is that I think there was further evidence that Slavin was definitely just answering the questions he was asked, and he wasn't being dishonest because he had already reported both statements to Chief Rodwell a month earlier. So he didn't have a reason to hide it then. Just as I was trying to find a reason why Minor wasn't as forthcoming, but his circumstances are different.
Is it common for you to investigate matters involving a self-reported violation policy?
Trying to think if I've ever done that before. I don't know if I've ever investigated a person who has reported a self-violation. Nothing comes to mind.
That is unique in your experience?
Yes.
In your experience, we talked earlier about different AR 333 violations that meet at different levels. In your experience, do these investigations sometimes happen at the supervisor level?
Yes.
And that's appropriate?
Yes.
And not every AR 333 violation inside the city of Scottsdale requires a police internal affairs investigation, is that right?
That's correct.
And not every AR 333 alleged violation inside the Scottsdale Police Department requires a full-blown internal affairs investigation, is that right?
That's correct.
Okay. And in the absence of a full internal affairs investigation, it's incumbent on that employee's supervisor to conduct the investigation. Is that right?
That's correct. That's my understanding.
And who is Assistant Chief Slavin's supervisor?
It'd be Chief Rodwell.
Excuse me, Counsel.
Yes.
Ms. Cronin, my understanding is you went first today because you have some time limitations.
Actually, I don't today. I have them tomorrow, so I think.
I was just worried that you had to leave in an hour. and I
No,
wanted to make
I'm
sure
sorry,
we
I
had
don't
time for
today.
everybody.
Today, I'm fine.
Thank you.
Tomorrow's the problem.
Yeah, we had to clear the day, but I didn't want to have her wait all day because she's on the clock and for her time. Do you believe that there was anything inappropriate about Chief Rodwell's initial informal investigation of Chief Slavin's comments before the IA was opened?
You mean where Chief Slavin came to him and told him what he had done?
Correct.
I mean, I don't know necessarily. I consider that an investigation by Chief Rodwell. I mean, my understanding what occurred was Slavin came to him and said, "This is what happened," and he felt terrible about it, according to Chief Rodwell. and they had quite a discussion about what had occurred. It was a lengthy discussion, and during the course of that discussion, Slavin said he'd like to draft an apology. So I'm not so sure I would call that an investigation on Chief Rodbell's part.
But certainly by the end of that conversation, Chief Rodbell had enough information to sustain a 333 Part 2 violation.
And he counseled him as a result, yes. So he reported it, they had a lengthy discussion, and Slavin received discipline in the form of a vocal counsel.
So in that conversation, both finding and discipline occurred?
Yes.
Okay. And we've already talked about typically you would need to do a more extensive investigation because typically people don't self-report, do they?
That's true, that is true.
One of the issues that has come up has to deal with the fact that there was a gap in time between the initial finding and discipline and the internal affairs investigation. Based on your review of the record, do you have an understanding of why that occurred?
Yes.
What is your understanding?
My understanding is somebody, or more than one person, they were complaining to POSA, and Damian Mendoza, who I believe was the head of POSA at that time, and maybe still is, had gone to Chief Rodbell and said, you've got a problem, I'm paraphrasing, you've got a problem and you need to investigate this. And I think the chief said, I've already handled it, it's done, it's over. And he said to him, if you want me to investigate it, put it in writing, but I'm telling you right now, if the investigation doesn't prove anything that I don't already know, and what Rodbell was referring to was what had occurred at the meeting and the statements made by Slavin, he said, I'm not going to discipline him again. You can't discipline somebody twice for the same incident.
That would be unfair to the employee receiving double jeopardy.
That would be a violation of his due process.
But ordering the investigation itself is a way for Chief Rodbell and for the department to ensure that there's a public record and to clarify any facts of concern.
Well, yes, I mean, I think, as, you know, Scottsdale, unlike some other entities, does have and tries to foster a good relationship with the employee unions. And so here we have POSA basically saying, you need to investigate this. And so I think it was what Chief Rodbell's way of saying, all right, in a fair and full disclosure, we'll look into it, but if there's nothing new that's uncovered, I'm not going to revisit discipline.
So in setting the union's expectations for discipline, do you feel that that constituted predetermination with any respect as to the factual findings in that investigation?
No, because I think Chief Rodbell was saying to Mendoza, don't be looking for discipline if nothing new is uncovered. Because Damian Mendoza, at least in his letters, appeared to, he wanted Slavin disciplined. So, and Rodbell was letting him know that he had already been disciplined before, and he wasn't going to discipline him again for the same thing.
It would not have been appropriate for anyone in the department to be asking their employees, did you tell the union, did you tell POSA, what did you tell POSA?
No, I don't think that's appropriate.
And you don't have any criticism of Chief Rodbell or the investigators for failing to ask those questions, do you?
No. Because I think employees, based on the relationship they have and the city has, employees are free to go and speak to their union representatives.
We've talked a little bit about criticism leveled at internal affairs for not treating Chief Slavin's statements as an integrity violation. Are you familiar with a case
in general where a different violation could be uncovered during the course of questioning?
Yes.
And you're aware that under the Arizona statutes, the investigator does not have to stop and issue any notice of investigation, is that right?
Right, I believe that's in the Bill of Rights.
Have you reviewed the city's general order regarding workplace behavior and inappropriate behavior?
Which order is that?
Okay, 2022?
I have. It's been a while, but I have.
I'll read you an excerpt from it, very briefly. This is defining inappropriate behavior.
Okay.
A, gossiping, defaming another employee, or acting in a manner that could negatively impact the workplace service or productivity. B, engaging in humor or bantering in the workplace that may intimidate, offend, embarrass, or demean another person. Does that refresh your recollection as to
Yes.
what the order says? When Internal Affairs investigated Commander Minor in his second interview, he had a slideshow with a number of other people that he'd spoken with about the slavery situation. Do you recall that?
Yes.
Commander Minor was speaking about the situation to not only his supervisor, but subordinates, friends, direct reports, and lower ranking officers outside of his chain of command. Is that right?
Yes.
He spoke with people who were not in the meeting or did not hear firsthand comments. Is that right?
Yes.
IA chose not to open a separate discipline investigation of Commander Minor for any potential violation of workplace prohibition against gossiping. Is that correct?
Yes.
Do you have any criticism of IA for failing to attach that additional charge to Commander Minor?
Well, they certainly could have, because you don't want people conducting their own independent investigations in the workplace for a variety of reasons. Ultimately, the decision for them not to do so is a call they can make. But I wouldn't have been critical had they chosen to open one, given the extent of the investigation Commander Minor appeared to have conducted.
Mr. Cronin, as I finish, thank you, first of all, for your testimony, and again, reiterate, I have never spoken to you before, and these answers are as new to me as they are to everyone else here. Overall, do you see any evidence in anything that you looked at that Commander Minor or Chief Slavin were treated differently or handled differently in any of the disciplines?
Now, based on the information that I reviewed and the people that I interviewed.
Is that a tentative conclusion or is that a firm conclusion?
No, it's firm. It's pretty firm.
Thank you. I don't have any further questions. Mr. Serrano.
Mr. Sabah?
Yeah, Ms. Cronin, you and I only talked by email, right?
Yes.
And there was only 2 emails between us. You first asked me if I had a position statement. I wrote back to you and said, yes, I'll get you one. And then I sent you the position statement that we sent, right?
Yes.
And you just,
There's one more.
I'm sorry?
There's one more email exchange we had.
What was the other email exchange?
Recently.
Oh, about the records. That's right. I'm sorry.
Yes.
During your investigation, I should have been clear. Later on, I followed up and I asked you for essentially recordings or transcripts. Right.
Well,
Okay.
and you asked me if I disclosed the executive summary.
Right. But
But-
during the course of your investigation, we had one substantive, you asked for that information, right?
Right, and it was related to providing me with additional information, yes.
Right. And you had the ability to interview Commander Minor if you wanted to, right?
Yes.
And you chose not to.
I chose not to because there was nothing for me to interview that he hadn't already been talked about or he hadn't already said.
Okay. And you didn't want to make a credibility determination as to how you would impact, how you would assess his demeanor, right?
Well, I didn't need to make a credibility assessment on his demeanor because during my investigation, I found no additional information that would address, I found no additional information that addressed, one, a couple of things, that the investigations were not handled according to policy, that there was an issue regarding an integrity violation. So I certainly didn't want to ask him about that again. and then have him possibly come up with another story. I'm not saying he would have, but I didn't want to delve into something that had serious ramifications, because I'm not the one who's going to be deciding the outcome of that. And so there was really nothing for me to interview Commander Minor on. I certainly read quite a bit that he provided. I read his executive summary, assuming he wrote it. And so there was no reason for me to interview.
Okay.
With regard to the issues I was looking at.
I'm going to jump around quite a bit to try to save some time. And Ms. Day did a good job of explaining. The board is very familiar with the facts of this case. So we're not going to do the typical lay foundation things that we do to try to get things going quickly. But if there's ever anything that you want me to go back and refer you to, I assure you I've got the citations that are here.
Okay.
But I just want to make sure that you and I are on the same page about, first, we're going to talk about the comparative case that you were asked to look at, Chief Slavin's case. Okay? Now, tell me if I have this right. Chief Slavin made remarks at a meeting, right? And it's your conclusion that he made two separate remarks, correct?
Are we talking about 048?
Yes, the first investigation.
My understanding is he made two comments, yes.
Okay. And as a foundational matter, do you agree that it would be offensive to someone who is gay to have a assistant chief turn to them and ask, "What, are you gay?" as a joke during a meeting?
Well, I think it's more than that.
Okay.
You don't have to be gay to find that that comment is unprofessional.
Okay, but would a reasonable gay person find that comment inappropriate?
I think there could be an argument as such, yes.
Is that your belief or no?
If it was directed to a gay person, they said, "Are you gay?" I think a person could find that, a reasonable person could find that inappropriate and unprofessional. But I don't think you have to be gay to find that.
Do you find it offensive?
I find it unprofessional and inappropriate in the workplace.
So my question is, do you find it offensive?
Offensive to me, no, I don't find it offensive. I find it unprofessional and inappropriate. It's just not appropriate.
Okay. But you're not offended by it?
No.
Okay.
Counsel, I want to tell you the questions asked, but isn't the issue whether we create a hostile work environment, is that term defined in the law? I know we've talked about, the investigators yesterday talking about whether or not someone was offended, but is that really the issue, or is that the standard used by the city of Scottsdale, which seems inconsistent with what a hostile work environment is? So that's...
My perspective is that, and I'm quoting from the policy, the legal standard used to determine if the conduct is inappropriate or objectionable is whether a reasonable person, as a member of the protected class, would view it that way. For example, whether a comment of a sexual nature is offensive to a woman would be determined from the perspective of a reasonable woman, i.e. would the comment be offensive to a reasonable woman? The same standard applies directed to members of the protected class. That's Scottsdale's policy.
Right, but that's not the law, because unless you broaden it better, more than what that language is, because a Caucasian person could be offended by the use of the N-word.
Right.
And that could create a hostile work environment toward the Caucasian.
Right, and my question...
We only, that's an executive session question. But, okay, I just wanted to indicate that I thought we were going down the wrong direction.
No, I was trying to stay to Scottsdale's policy. So, in this instance, and I mean, I'm just trying to determine whether somebody being offended is actually required for it to be part one or part two.
Well, let me just, because there was, in that discussion, if I could, part one, you have to label which part we're talking about. Part one of AR 333 follows the federal law insofar as if I bring a case and I say that so-and-so made a comment because as a woman, I am offended by it, then under federal law, to determine whether it meets a violation of Title VII, it's a reasonable woman standard. But when you're looking at part two, where you have behavior that hasn't risen to the level of the Title VII violation, where it's unprofessional or inappropriate conduct, it's whether it's inappropriate in the workplace, and it doesn't have to be that it violated, it doesn't have to be a reasonable woman or reasonable person. It's whether it's just inappropriate and unprofessional, and that part 2 gives examples of that type of behavior. So you have to clarify which one you're talking
I
about.
apologize, Mrs. Miller, because otherwise they'd have to ask foundational questions. Over time, you talked about it, if it's a sexual comment that it's a woman, a reasonable woman standard. Isn't the standard a reasonable victim standard? Because otherwise, if someone says to a Caucasian, "You're just the house end," that's offensive, but they're not an African American, they're a Caucasian. So it's the victim, isn't it? Not the reasonable. I know the case you're talking about talks about a reasonable woman, but I thought that's what extends to a reasonable victim.
Well, it depends, because it has to be a protected class
Right.
under federal law. And, protected classes, a white male, unless you're talking about age or gender orientation or sexual orientation, a white male is not part of a protected class.
Well, but they can be subject to sex discrimination on Cobb versus Sundowners. That.
Yes, but a discrimination based on sex, that's a different definition. And I'm sorry, I don't mean to be confusing. In order to establish a claim of sexual harassment, it has to be conduct of a sexual nature that is unwelcome.
Right.
And if you have that, then you've established sexual harassment. You don't get into a reasonable person
Exactly.
standard. So it's a different, we're not dealing with sexual harassment here, but that's a different definition. So if I'm claiming sexual harassment, that I was sexually harassed, and the other side proves, well, it's usually clear that it was conduct of a sexual nature, but if they prove that it wasn't unwelcome, that I welcomed it, then I lose my case.
Well, I'm trying to remember, it was the case in California, the banking employee who had relations with someone in order to stop it. I'm sure the case was like early 2000. It established it's voluntary and unwelcome. That was the question.
Right.
So something can be voluntary and then turn into something unwelcome.
Especially, and that's why so many employers have such a harsh policy with regard to when supervisors start dating subordinates. Because is it really voluntary, or is it unwelcome, or both? Because there is such a high,
We have a comment that's made, listening, it was sort of like you need a victim, you need someone to be offended. But this, I would assume, rumor mill, everyone knew Chief Slater made the comment. So people not even in the room could be, it could be unwelcome to them. Is that a fair statement? Which gets into the whole idea of hostile work environment.
well, yeah, let's say I'm not in the room and I heard that he made that, I could say, yes, that's not appropriate, and he shouldn't have said that.
But it doesn't give rise to a Title VII.
But it doesn't give me a claim.
Well, it could be a claim if you're ultimately subject to discipline or termination or an adverse employment action, right? You need, to have a lawsuit, you need an adverse employment action. You have to be damaged, injured.
Well, right, right, you have to be damaged, but, yes.
I guess my concern is if you start having comments like this in the workplace and virtually nothing is done about it, at some point when someone is damaged, as you know, the EEOC comes in and says, okay, we want to know all the complaints of discrimination that occurred in your business. And then the other question that sort of raises here, I apologize for asking this question, is this is categorized as a inappropriate, I forget the term, unprofessional conduct. If the EEOC came in and said, we want to see your discrimination complaints, would anyone even see this? Because it's categorized as unprofessional conduct. And that's a question I'm not sure, unless we get personnel, it's probably not relevant. That could be a concern, that you're not giving all that information because you don't consider it Title VII.
Well, let me answer two, because there's two parts to that question. as I said, and I said earlier, that when you have this type of behavior in the workplace, where these two comments were made, single episode in this meeting, the employer should address it, because if they don't, and they allow this behavior to continue over a period of time, it could end up and create a hostile work environment. So that's why you need to stop it.
Right.
Now,
Slavin made those comments into the future.
if you kept making them and Scottsdale did nothing about it, it could result in a hostile work environment.
Let me answer that. I know I'm interrupting. How do we know he didn't make those comments in the past?
Well, it hasn't been reported that he has.
Right. And that's also a concern. He's the assistant chief. He made comments like that to a control officer. The control officer had reported them. Whereas here, you know, it's somewhat internal by two of the officers opposed to him. So that's a concern I have.
Excuse me, Mr. Chairman, I'm sorry, I have to interrupt.
I'm going way off.
This, Chief Slavin is not on trial, he's not here, and my concern is that Chief Slavin does not have any legal right to defend himself, to put on witnesses, and if you have a concern or speculation that this forum is not a fair hearing, it's not a fair way for Chief Slavin to be heard, to put on witnesses. And so if you're speculating on things that are outside the record, and respectfully, I understand that you have to draw inferences, and I don't mean to suggest that you can't, but if you're going to go outside the record and outside the testimony that you hear about Chief Slavin, that just please keep in mind that Chief Slavin does not have the ability to defend himself in this case. He is a witness only. He has rights under the Peace Officer Bill of Rights to have witnesses, to have a representative, and none of that has been put in place. That we need to keep the hearing focused as much as possible on Commander Minor and the historical practices for justice, and also to comply with statutes. So just, if you could just please keep that in mind respectfully. Thank
Counsel,
you.
my questions in that regard are absolutely not intended to consider anything about Chief Slavin. My concern is the manner, because I think it would maybe subject to another board meeting, probably agendized, is whether the investigation, any of these investigations, are conducted properly, where there is the standard, this will hopefully agree that is the conduct severe or pervasive. And here, it's clear that the conduct wasn't severe. I mean, it was questionable as unprofessional. If it wasn't severe, it's not using words, it's not touching, things of that nature. But the problem is, there was no, from my perspective, there was no investigation of pervasiveness. And there was no record of it. There was absolutely no written record of anything, of the conversation that was done at a level other than the email, which was somewhat unclear. So that's my concern. But I want to reiterate my questions, and I'm very well aware. Chief Slavin is not subject to this matter, but he ends up being the person who gets targeted, because the other concern I have is that everyone knows he made the comments, and he had to, he writes his email, which is broken, but the city doesn't do anything. It doesn't even say, just to remind everyone, comments of an improper nature under AR 33 will not be tolerated in the workplace. At least the employees know that management's aware of it, they've done something. May not be, people will disagree with it, they may agree with it, they may say various things, but at least they know management was aware of it. But I don't think that type of comment is a release of personal information that may be barred. Making a general statement that we're going to do some new training or just a reminder, I don't think that's a problem. It does, that may be another issue, which is unfortunate. That's my major concern here. Again, reiterate for the third time, in no way taking any action or suggesting any action should be taken against Chief Slavin in this case, or what we've heard so far.
welcomed a discussion, a larger discussion about overall policies and practices. But again, this hearing can't be that forum because of the restrictions that are placed on us by the Peace Officer Bill of Rights. I think that your suggestion of agendizing another board meeting, that's not something that we intend to shy away from, and we're for transparency and accountability. But I just want us to make sure that we're keeping that in mind and keeping track of the fact that we have strong restrictions on things that we can bring forward, and we just wanted to make you aware.
Apparently that may, we've had a really good conversation about that whole aspect.
Yes, indeed.
But I apologize, Mr. Salata.
Thank you for letting me be heard. I appreciate that.
In your opinion, Ms. Cronin, is it prohibited conduct in the city of Scottsdale to turn to a individual at a meeting and say, "What, are you gay?"
Yes. I think so, very much so, yes.
So therefore, retaliation against an employee for reporting an act to believe that they believe is constituted unlawful discrimination would be prohibited by the AR, correct?
Well, it depends how that happens. So my understanding is that comment was directed to, I think it's Lieutenant Myers. So, and interesting enough, he never made a complaint about it. But he certainly could have if he had been offended by it, and maybe he was offended and chose not to, I don't know. But he didn't make a complaint.
Commander Minor did make a complaint, though,
But
right?
Bonnet did make a complaint to Commander Minor about that he was upset by it. And Commander Minor, like I said, rightly so, went and complained to his supervisor. So if Bonnet was disciplined after he made those comments and there really wasn't a basis for discipline, that could be considered retaliation because he made a complaint to Commander Minor.
Well, Commander Minor also made a complaint to Chief Pop, right?
He did.
So retaliation doesn't have to involve discipline. Retaliation can involve any employment action, right? An adverse employment action?
It can involve an adverse employment action, yes.
Okay. So,
But making a complaint of discrimination or making a complaint of unprofessional behavior is not a shield from discipline.
right. Okay, so I want to talk about the comparative case because I want to make sure that you and I are on the same page with the timeline. So if I have anything wrong from this, and this is an effort only to do this quickly, so if you need me to stop or if I have something wrong, let me know.
Okay.
It's my understanding that Chief Slavin made 2 inappropriate remarks at a command staff meeting.
Yes.
The next morning, Lieutenant Smith talks to Chief Slavin and says, "Hey, you made a comment about either a newspaper or a commander or whatever, and then you actually turned to Tommy Myers and said, 'What are you gay?'" And Chief Slavin goes, "Oh my gosh, I didn't even realize I said that." So at that point, Chief Slavin has been informed that he made 2 comments, right?
I'm not sure when that, I don't disagree with you that that discussion occurred. I'm not sure in the chain of events when it occurred.
Okay, well, you can, if you need me to refer you to the record, we can do that, or you can accept my kind of assertion.
You believe it occurred before he went to Chief Rodbell?
Well, per Lieutenant Smith, and I think per Chief Slavin's statement,
Okay,
Chief Slavin
if
says.
that's what they say, then I agree with it. I recall, as I sit here today, there was a discussion along those lines.
Okay, so
between those two.
we're at 2 comments there, right? And that
Yes.
was your unequivocal testimony that you concluded that Chief Slavin told Chief Rodbell about both of the inappropriate comments, right?
Yes.
Okay. And then after that meeting with Chief Rodbell, it's undisputed, I think, that Chief Slavin sends out the email to the meeting attendees, right?
Yes.
And in that email to the meeting attendees, Chief Slavin only recognizes one of the comments that he made, right?
You know, I can't remember what the email says. I don't remember what it said exactly.
You don't remember if it was singular or plural?
I kind of remember he said something along the lines like, I acted inappropriately. It was like a global, that's what I recall. I just don't remember if you can give me what he stated, then I can respond, but I just don't remember off the top of my head.
Okay. I mean, the record speaks for itself, but I'll move on to that. If you can accept my assertion that it was a singular comment.
Well, I don't remember, so I can't accept it or not. I think he meant it more as a global. He wasn't breaking it out.
So you didn't see any, that didn't flag to you as, hey, I only accepted responsibility for one comment?
No, because he had already, and this is per Chief Rodbell, told me that he reported both to him.
Okay.
So there's no, and like I said, maybe the wording was inarticulate, but as I recall when I read it, it was, I acted inappropriately. I said, and it made an inappropriate statement, and maybe it should have been statements, but,
Okay. And then, after that email came out, much later when he was interviewed, he was only asked about one comment, right?
Right,
And he only talked about one comment, right?
because that's all he was asked about.
Okay. Now, in the end of his interview, Chief Slavin was asked, is there anything else that you want to add, right?
I don't recall if he was asked that, if he was, okay.
Okay. And in that statement, when he was asked, is there anything else you want to add, he only talked about apologizing for a single comment. Do you recall that?
Yes.
That's not a concern to you?
No, because again, he's the target of the investigation, and he is being asked, he needs to be truthful, but he needs to answer the questions that are asked. And, the other problem is that really, he was the first person interviewed. And I think Lewis at that point really he was still trying to figure out what this was all about, because he just had that letter from POSA. I think his interview would have been much more directed and targeted, and Lewis would have been able to ask, for lack of a better term, better questions, because he would have done Slavin at the end.
Well, help me out with that, because Chief Slavin was given a copy of Damian Mendoza's email at the beginning of the interview, right?
I believe he was. Yes, because it's the complaint, so they considered that to be the complaint.
Yeah. And then Damian Mendoza's email is real clear about also making a homophobic comment.
Well, yeah, I don't think Damian Mendoza's letter is clear at all. I think this is the first time now it's couched as a homophobic comment. But it doesn't say who was offended by the comment. So, no, I don't think his, and then I will tell you, I remember Lewis saying he circled back to Damian Mendoza to try and get more information, such as who was at the meeting, because Lewis didn't even know that. And he still didn't get very clear information.
Were you informed that Damian Mendoza blacked out the names on the email before he sent it to POSA?
I think I was.
Why do you think he might have done that?
I have no idea. You have to ask Damian Mendoza.
Could it have been to protect the potential person bringing the claim forward?
Well, if he did, that makes no sense, because why was he insisting that there be an investigation?
Let's talk about that, right? Who was the first person that reported this misconduct up through their chain of command?
Slavin
Who was the second person to report misconduct up through their chain of command?
would be, from what I understand, is Commander Minor on Tuesday.
Yeah, well, actually, let's go back. So let's be fair, because Lieutenant Bonnet, immediately after the meeting, reported misconduct to Commander Minor, right?
Yes, so he would be the first.
Right, so Lieutenant Bonnet did. And then Commander Minor actually talked to both Chief Slavin and Chief Pop about the inappropriate nature of the comment, right?
He had a discussion with Slavin, I think it was Friday morning, but again, Slavin's not in his chain of command. I mean, he's superior to him, but he's not in his chain of command.
Sure.
And then Pop was out of town,
Right.
so it's not that he intentionally delayed it. He spoke to Pop on Tuesday. I think Pop came back into town on Monday, but he had a chance to speak to him on Tuesday.
Okay.
And that would be appropriate, because that's his chain of command.
Okay. And then Commander Minor was told by Chief Pop that Rod Bell's handling it, essentially, right?
He didn't say handling, he said it's already been handled,
It's already been handled.
because it already had been handled.
Was it reasonable at that point for Commander Minor to believe that there wouldn't be an investigation or formal investigation into this matter?
Yes, because it's already been handled.
Okay. Would it be misconduct for Chief Slavin to essentially provide false information to Chief Rod Bell about the comments that were made in the meeting?
Well, it depends what those comments were. What are you saying that was misinformation?
Well, the apology email that was sent out, as it's being characterized, didn't describe what the comments were, correct?
And I don't think it should have. I think that would have been inappropriate.
Okay, so there was no public record of what Chief Slavin actually said, correct?
Well, nobody was recording the meeting. So, no, there would not have been a public record created because there was nothing in writing.
Okay.
And it wouldn't be, I don't think, there's no obligation on Slavin's part to sit there and say, I'm sorry I said X and I'm sorry I said X.
Was there an obligation on the city's part to investigate the complaint that was made by Lieutenant Bonnet and Commander Minor?
There's nothing left to be investigated because Slavin is self-reported. He, per Chief Rodbell, informed him of what had occurred. And we know that because Chief Rodbell, if he hasn't testified, which he will, at least he told me, that the investigation that ultimately occurred, there was nothing additional discovered. And so I'm not so sure what the city should have investigated at that point.
Well, help me out with this, Ms. Cronin, because I have just conceded that Lieutenant Bonnet and Commander Minor brought forward a complaint through their chain of command, correct? And up until the union complaint later on, there was no documentation as to what occurred at that meeting, correct?
Right.
So you have two members of the Scottsdale Police Department who formally said, something happened at this meeting, it was wrong, it violated AR 333, correct?
Part 2.
Doesn't matter, I'm saying AR 333.
Well, it does matter. It's a distinction with a difference.
So you think they don't have to document violations of AR 333 Part 2?
Well, he gave him a verbal counseling. So if you document his verbal counseling, now you've turned it into a written counseling, which is a higher level of discipline. And so, you know, so these are lower level, it's unprofessional conduct in the workplace. We're not talking about violation of federal law. And so he reported it to his chain of command. His chain of command, Chief Rodbell, disciplined and gave him verbal counseling. There's no requirement that that be put in writing. And if you do put it in writing and you put down that Chief Slavin received a verbal counseling, now you've made it a written counseling. Because now it's in writing.
And there's no requirement under AR 333 for the city to investigate and document what was actually said. That's your position?
Not based on these circumstances.
Okay. So let's just play a hypothetical because I think it'll be helpful to the personnel board. So Chief Slavin said this comment, "What, are you gay?" at a meeting, right? And he got a verbal counseling from the chief. Hey, don't do that. Under your theory, Chief Slavin could say, hey, what, are you gay? And that could be his favorite joke at every meeting. And the city would never have to document it as long as he got a verbal counseling every time, right?
That's not what I'm saying at all.
Well, what's the difference?
I said the exact opposite.
How do we know that doesn't happen if there's no requirement to investigate when people bring forward misconduct?
First of all, it would, Chief Rodbell would know that Slavin had received a verbal counseling. And if he hears that he says it in, because these are monthly meetings, that he says it, say, a month later in your hypothetical, and it gets back, and let's assume Slavin doesn't report it, but somebody at that meeting says, Chief, or Commander, or Assistant Chief Pop, or whoever, he said it again. Well, at that point, does there need to be a formal investigation? No. But Chief Rodbell needs to address it, or because he's Slavin's supervisor. And at that point, I'm sure HR would get involved and say, okay, we gave him a verbal, it clearly didn't do the job, he doesn't get it. So now we need to proceed with progressive discipline.
So it's your understanding of AR 333 that even after you have members of the Scottsdale Police Department, two supervisors that said, I believe there's a violation of AR 333, that no investigation needed to occur. That's your understanding of the policy.
My testimony is, as I said before, based on these facts and this circumstance, and the facts of how everything occurred, that when Commander Minor made the complaint to Pop, it was not necessary to do a formal investigation.
How does Chief Rodbell know when he's talking to Chief Slavin that Chief Slavin accurately reported what Chief Slavin said at the meeting?
He had no reason to doubt him. Chief Slavin is coming to him and saying, I said this and that, and you know, those are questions you're going to ask Chief Rodbell. Chief Rodbell told me that he had no reason to believe that Slavin was lying.
Chief Rodbell had no reason, you don't think Chief Rodbell had a reason to initiate a formal investigation or even document what occurred after he gets a report from members of his chain of command?
Not of something of this nature.
Okay.
Otherwise, they'd be documenting probably a lot. I mean, not of this nature.
Yeah, they would be documenting it when people turn and ask about sexuality in a formal meeting, and you think that that's not required under the personnel?
Well, actually, that's a mischaracterization. Based on my understanding of the statement, it wasn't that he was asking Lieutenant Myers about his sexuality. He made a blunt statement, "Are you gay?" And he didn't insist that he answer it. It's not an appropriate statement, and I'm going to keep saying that. But I don't think that that statement made in a meeting needs to trigger a formal investigation. And I will tell you, based on my experience, I've never seen a single comment like that trigger a formal investigation.
You don't think that it's a best practice or the requirement of policy for Scottsdale to document what was said?
I don't think it's necessary for it to be documented because Chief Rodbell has handled it and he's disciplined the employee. Now, he may have documented it in a supervisory file that they had this discussion. I don't know. That's a management issue that he deals with and how he handles that.
No, Chief Rodbell was copied on the apology email, right?
My understanding is yes.
And if that apology email only
Yes, he was.
takes responsibility for a single comment and not both comments, would that rise to a level of concern that, hey, maybe I'm not getting the full story?
No, my answer is going to be the same as I responded before.
Sure. Okay, I'm going to move on to a different thing, and we're going to come back to that before. So I don't want to make this a vocab test, so maybe you don't know this, but I'm quoting from the usage section of Merriam-Webster's dictionary, which is that uppity has a long history of being applied to members of racial minorities and especially to black people. Its association with such uses and the bigotry they represent means that when it's used to describe a member of a racial minority, it's likely to be considered especially offensive.
I'm going to object to this testimony under the Peace Officer Bill of Rights. The city is entitled to your exhibits beforehand. If you're going to introduce the dictionary, the other reason, because I too looked it up last night, I'd ask you to read the primary definition and the secondary definition and not conceal the fact from the witness that the primary definition is not noted as derogatory if you go on merriam-webster.com.
I'm going to sustain the objection, but I think there's a question that can be asked that needs not refer to Webster's dictionary. The question is not whether she's familiar with the dictionary definition. The question is whether she's familiar with the racial history of that term.
Are you, fair, I'll withdraw.
Either she is or she isn't.
Fair. Are you familiar with the racial history behind the term uppity?
I'm going to answer this way. I've been accused of it. So to me, I don't see it as a term that denotes a racial connotation. Now, I'm not denying there might be a history to it, but I don't see it as a term that is used exclusively towards gender. That is my experience, because I've been accused of that.
And actually, and I apologize, actually, for this, they should have not even had you ask her, because the question is whether the chief does, because he's the one who used it.
Sure, I mean, it's...
So I think, maybe move on to something.
Sure, and I mean, it was foundation for the next question. Do you believe that a reasonable black man being described as hanging himself in conversation is appropriate or objectionable?
What do you mean?
Well, if you said that Commander Minor hung himself...
If I said that
yeah.
to Commander Minor, do you believe hanging yourself, I'm sorry, tell me what I'm supposed to say.
Do you believe that a reasonable black man being described as hanging himself in a conversation is inappropriate and objectionable?
Okay, the problem I have with your question is that's not it. It's would a reasonable black person find that statement made, depending on the context, as offensive? That's the test. But I don't know, you haven't given me context as to how that statement is being made. Do you see what I'm saying?
Sure, in your conversation with Chief Rodbell, you made characterizations of Commander Minor as hanging himself, right?
Right, but that to me is just, I make that about everybody. I mean, you don't want to, you're your own worst enemy. I can say that too.
Right.
I think this is an example of that. So.
do you think it would be reasonable for a black man to be offended if they read about a conversation where they're alleged to have hung themselves? Do you think that might have a racial
I think it
tinge to
depends on the context, and it depends how it's,
Counselor, I think you need that also.
Okay.
That's-
So, moving back to what you were asked to do, the city attorney's office is your primary contact, and they're the ones that hire you for your repeat jobs with Scottsdale, right?
Sherry Scott has been the person, my main contact,
Okay. On multiple different issues, right?
on multiple investigations that I've done, yes.
And they put forward a position in this case, and they strongly advocated that the actions of Chief Rodwell were within policies, practices, and procedures of the city of Scottsdale, right?
I object to
I
one of the
would
passages
disagree with
as far as who's providing a report.
Did the city attorney's office present a position statement on this?
I did, just like you did.
Okay. Did a member of the city attorney's office provide a position statement on this issue?
You can answer.
I mean, I was given I gave them the same opportunity that I gave you, and they provided the January 30th letter.
Okay. And they put,
Just like you gave me all of your exhibits.
Sure. I'm just saying that you got a position from the city attorney's office.
I got it, no, it wasn't a position. Position to me means they're advocating. What they gave me was their additional information, as you gave me the executive summary.
Okay. Help me out with your understanding of this. So does the word directly and the phrase directly offended mean anything?
Not to me.
So literally you can take it out and it has the same meaning?
It's not a term that is used in the Title VII context, either for violation of federal law or unprofessional behavior. Is it unprofessional or not? And I don't know, directly offended, I don't know what directly means. If it's a violation of Title VII, it's a violation of Title VII.
Okay. You were asked questions related to your interviews of Chief Rodwell, Chief Pop, Sergeant Gallagher, and Sergeant Lewis. And you made statements that you conducted no other informal interviews, correct?
Regarding this issue, that's correct.
And I think you said you had no off-the-record statements or conversations with anyone else that you interviewed, right?
Well, we talked before we went on tape, and I explained to him who I was, why I was there. And I know with Chief Pop, my tape stopped, and we were about 20 minutes into the interview, so I had to recap what we discussed, but that was unintentional. And then we probably talked after the interviews, but it wasn't about this, that I recall. But I'm trying to think if I spoke with anybody from HR, and I don't think I did in this case. So no, everybody that I talked to about the specific details of this case was recorded.
So I'm quoting from the beginning of your interview with Chief Rodwell. All right, today is February 14th, 2020. Present is Chief Alan Rodwell. Thank you for coming. And we talked a little bit off the recording. I just kind of went over with you some of the documents that I've, particularly a 22-page document that I received from the attorney who is representing Commander Minor in this matter.
Right, that's what I said.
So you talked about...
That's consistent with what I just told you, that we discussed, and I explained to them why I was here. And particularly with that, I gave them an opportunity to read it because it was the first time they'd ever seen it. And I didn't want to start asking questions without giving them a chance to read it. And I explained to them what it was because it just says executive summary. But we didn't go into the nitty-gritty of the contents because I saved that for the recording. And that's why I put it on the tape because I wanted it to be clear this is what occurred prior to me turning on the recorder. But I'm not going to turn on the recorder while he sits and reads. I think it's a 13-page single-spaced document.
So you thought it was okay to have at least some conversations with these witnesses about the document off the record?
I didn't have conversations with the document's content. I gave them an understanding of where it came from, how I got it, and why I was going to be asking them about it. So I gave them background, and I think that's appropriate. And I put on the record that that's what I had done. So there was no nefarious intent on my part.
Okay. Now, you talked about the differences between your expectations for witnesses and subjects of an investigation. What policy says that subjects of the investigation do not need to follow the same standards as witnesses?
Well, as I said earlier, there's no policy per se, but it's just an understanding. And this even goes with testifying at trial. You know, what is the first thing you say to your client who's being accused of something or is a defendant in a civil matter? Do not volunteer information. Answer the questions that are asked. Same thing in a deposition. A witness is not in that situation.
So there is no
And that's
policy?
what I said earlier.
There's no
There's no policy in the city of Scottsdale that says somebody who's the subject of an internal investigation only answers the questions that are asked. What it does say is they need to be truthful.
Incomplete, right?
I don't know if it says complete, but if it does, I'll agree with you. I just can't recall. I know it
Okay.
says truthful.
Now, you were provided with previous AR 333 investigations by Scottsdale, correct?
Yes, in the January 30th letter.
And there was evidence that it was the practice of the Scottsdale Police Department to investigate allegations of AR 333, correct?
Yes, but there's one that was listed that was actually investigated by a person from Human Resources.
But that investigation by Human Resources at least documented what occurred and violated the policy, right?
I think it did say it violated policy, if I remember right. I'd have to look at the letter. There was a lot of IAs they gave me and I don't have them all memorized. So if you want to ask me details, I'm going to have to look at the letter.
Okay. Well, related to the Slavin investigation, you said that there were two anomalies related to the investigation, if I understand it right. The first is that Slavin self-reported his violation of AR 333, and the second was that the complaining witness was not the offended party or present for the misconduct.
Can I refer to my report? It's in my report.
Sure, yeah, and it's on page 330 of my exhibits.
Which are your exhibits?
So mine are in the iPad, actually, so.
Okay, I brought my report.
You can-
If I look at my copy?
Yeah, we can match it up to your copy. So
Let's
it's
be quicker.
page 2 of your report, which is
Okay.
again minor appeal 330.
Okay. Yes, the first anomaly, you're correct, concerned the facts Slavin self-reported. The second was that the complaining party was not somebody who was at the meeting.
Okay.
That's referred.
Counsel, we're on page 2 of her report dated January 29, 2019.
Yes, which has,
Paragraph where we at? I see.
so it's in the paragraph that's number 1, did the City of Scottsdale Police Chief Alan Rockwell act appropriately? And then about,
What's the first few words?
there were, however, 2, and then she is the number 2 of them.
That doesn't have that. I
What's
got
it?
something up in the left-hand corner, so January 30, page 2.
Oh, that's the letter, that's not my
Oh,
report.
okay. Now I'm looking at page 2, February 3, 2020.
I think we're talking about page 2453.
2453.
Or it's page 330 in my exhibits.
2453.
I have to tap on it.
Oh, is that exhibit?
The city's budget.
Yeah, I'm looking at these estimates. Okay, you're typing it. Okay, I got it. 2453, the first page. 2453, what page are we looking at?
So it's page 2 of her report?
Did the City of Scottsdale Police Chief
Yes, and it's about
Okay.
a third of the way down that.
Okay,
paragraph.
thank you. Thanks.
So the first anomaly that you addressed was that Slavin self-reported his violation of AR 333, right?
Yes.
Is there anything in AR 333 that allows an investigation to be avoided just because an employee self-reports conduct?
It doesn't say if you self-report, that means there won't be an investigation. But AR 33, I believe, doesn't even really talk about when an investigation is going to occur.
Oh, okay. The second anomaly that you addressed is that the complaining witness was not the offended party or present for the misconduct, right?
Yes.
Now, does this anomaly have any material impact on whether or not the conduct violated AR 333?
It doesn't have any impact on whether the conduct violated either Part 1 or Part 2 of AR 33, but it does have an impact as to, if you will, the strangeness of the internal investigation, meaning that it occurred a month later, and the order of witnesses, and that Lewis, you know, usually when a person does an internal investigation, they know who the person is that has made a complaint. And we didn't know that.
Okay. So
Other than they claim Mendoza as the complaining party.
well, you note in the same paragraph that the investigators, to your point, had very little factual information at the onset of the formal investigation, right?
Right, he just had Mendoza's letter.
Okay. But your investigation revealed that Chief Rodbell, who initiated the investigation into Commander Minor, was aware that Commander Minor had made a complaint to Pop about Slavin's misconduct, right?
Oh, prior to the start of 085? Yes, I believe Rodbell knew that Minor had complained to Pop.
Right, and this Minor's complaint to Pop occurred on May 14th, right?
Is that Tuesday? It was yes, if that was the Tuesday, yes.
Okay, and that's about 5 days after the misconduct?
Right, the meeting was on May 9th, which was a Thursday.
Okay, and during this complaint, Commander Minor addressed both his offense at the comment made by Slavin and also informed Chief Pop about Lieutenant Bonnet's offense as well, right?
Yes.
So, you agree that Minor's actions in making this complaint to Pop complied with AR 333?
I think Minor acted appropriately in making a complaint to Pop.
Okay. And then you'd also agree that Chief Rodbell withheld this information from Sergeant Lewis at the onset of the investigation into Slavin's misconduct.
I think withheld is an overstatement, as I testified earlier. I think that Rodbell acted appropriately when he agreed, because of Mendoza's pressure, if you will, or harping, to agree to do the investigation, and I think it was appropriate for him to hand Lewis the investigation without giving him any background, because otherwise we'd probably be sitting there and the accusation would be that Rodbell was trying to direct the investigation.
Explain to me that belief. So if Rodbell said, hey, I already got an official report from Lieutenant Bonnet and Commander Minor that misconduct occurred, and now I have this union thing, is that a violation of some type of policy or procedure in the city of Scottsdale?
Well, as I testified to earlier, I don't think there's a policy that says this is how you do an investigation when you initiate it, but I think that everybody will agree that when a formal investigation is started and the chief has ordered it, as was the case here, it's not appropriate for him to be giving facts to the witness or to the investigator, because then the allegation could be that Rodbell was picking and choosing facts to give the investigator in a method to direct the outcome of the investigation. So what he did, which is how most investigations occur, the people who are assigned to internal affairs get a copy of a complaint, whatever information they have. Here it was Mendoza, and they begin their investigation. They don't have a sidebar meeting with the chief of police or a sidebar meeting with the supervisor to find additional information. If they're going to interview him, it's going to be part of the internal affairs investigation.
And it's your professional belief that Chief Rodbell is saying to Internal Affairs, I received a complaint from Lieutenant Bonnet and Commander Minor about this. You think that that's an inappropriate fact to tell to Internal Affairs?
I don't think he needed to tell them.
Do you think it would have been helpful to Internal Affairs to have that information early?
I think Rodbell, and you'll have to ask him, but if if I was the chief of police, I would be hopeful that that information would come out in the internal affairs investigation. That Commander Minor would have said, yes, I made a complaint to Chief Pop, but he didn't do that. So if he had told the full story, there's no need for Chief Rodbell to have a pre-meeting as to the facts that he knows.
I thought you said that there's a value in identifying complainants early so you know who to interview first. Is that your testimony or no?
I'm saying that there's a benefit when you know who the complainant is, because most investigators will tell you that's who you start with.
Is it normal for a police
And-
chief to withhold the identity of a complainant from internal affairs investigators?
First, I don't know who was withholding.
Well,
The
Chief
person
Rodbell,
who-
if we
Can you
could-
let her finish, please?
The person who withheld from Lewis was your client. And Lewis has testified, or at least he told me, I don't know if he's testified yet, he told me that had he said to him that Bonnet was offended, he would have immediately interviewed him. And his failure to do so had ramifications. So it is important, and you know, he shouldn't have withheld it.
Do you think that, is it your understanding based off of your review of this investigation, that had Chief Rodbell told Sergeant Lewis Bonnet was offended, he previously filed a complaint that I chose not to investigate? Do you think that would have impacted Sergeant Lewis's?
I don't know, well, two things. I don't recall if Rodbell knew at that time that, well, I think he did. But again, you're asking me the same question, did it a different way, and my response is the same. I don't think it's appropriate for Chief Rodbell to have pre-meetings with his investigators. Secondly, I'm not so sure, and this is Rodbell's going to have to answer, I don't know if Rodbell, if Pop had gone to Rodbell and said, these two people just, or Commander Minor came and complained to me, because I got the impression from Pop who said, it's already been handled. I don't recall if Pop went to Rodbell at that point, I just don't remember.
So you don't recall any witnesses telling you that there were multiple conversations between Chief Pop, Chief Slavin, and regarding Lieutenant Bonnet and Commander Minor making a complaint?
Well, I think there were down the road. When are you telling me these occurred?
Did you ask the questions as to when those occurred?
Well, I knew of them occurring down the road because this whole episode, we had the 04A. I'm not aware of any, and I don't recall any occurring in June, but there were a lot of discussions after 04A was completed because that was circulating, and then as I recall, 085 didn't start till it was either the end of September or October. There was quite a length of time.
Okay.
So I just can't answer a broad question like that.
Would that be important information for you to know as to whether Chief Slavin was speculating about who had brought forward a complaint against him?
Well, first of all, I don't know, I mean, I'm sure he probably did speculate. You know, that's just human nature. But it doesn't matter because Chief Rodbell gets to make the decision. And POSA went to him and said that they were getting complaints, that they used the word plural. And Rodbell said he was going to conduct an investigation.
Okay. So you noted that Rodbell only agreed to initiate the formal investigation after Mendoza submitted his request for the investigation, right?
He agreed because Mendoza finally put it in writing, and Rodbell said, okay, I will do it, but if I don't find anything else out that's new, I'm not going to revisit discipline.
And there's nothing in the AR 333 policy which requires a written complaint to initiate an investigation, right?
Not that I'm aware of, no.
In fact, the policy says that a supervisor receiving an AR 333 complaint must report it to HR as soon as possible so the complaint can be investigated thoroughly, expeditiously, and professionally, correct?
That's correct.
Council, the board has heard that a number of times. The board's read it a number, each of the board members have read that provision a number of times. We can move along.
Sure. Did your investigation reveal that Chief Rodbell made a notification to HR?
About this, about what?
About Slavin's comments?
You know, I don't recall, because I know they have an HR person whose name I can't remember. I believe it's Man. And he attends a lot of the meetings, and so, but do I know if Chief Rodbow specifically walked down the hall and spoke to somebody from HR? I don't know that. I don't recall that.
So he actually told you in your interview with him that he might have messed that up, right?
I don't recall. If you want to point me to it, I can answer that question.
Okay. It's on page 570 of my exhibits, and he says, I'm quoting from him, and it's on page 9 of his first interview. So he says,
You wait till she finds it.
I can read it to her. I'm just going to read the quote. So, because I asked for this, I mean, I don't know where the agreements came from, but I actually asked for this because the accusation is I mishandled the Slavin investigation because I handled it informally and I did not notify HR. If in fact the administrative regulation required me to send it to HR when someone walks into my office and tells me I messed up and I have no complaint and I have a conversation and we deal with it, if that was inappropriately handled, if I should have said, Rich, I really appreciate you telling me this, but I'm going to send this to HR for a full investigation. If that's the way we have to go, then I need to know that I messed that up. Because in the future, we need to make sure this never happens again. And so I'd sit here and tell you, bosses need to be able to talk to their employees informally about things. But if it becomes that formal, I need to protect my workforce from never making the mistake I just made. Does that sound familiar?
Yes, but again, I stand by my original question, or my original response is based on these facts, Slavin coming to him, reporting what he did. They had a discussion. Rodbow determined that verbal counseling was the appropriate form of discipline. There's no requirement that he had to go report that to HR. He has handled it.
And you think that's consistent with the policy language in AR 333?
Yes, I do.
So in your report, you actually didn't document the fact that Commander Minor had told Sergeant Lewis during Commander Minor's first interview that Commander Minor had went directly to Slavin and that Commander Minor had informed Slavin that Commander Minor found the comments were shocking.
Well, I didn't document it in my report because it wasn't a fact that contributed to anything. Slavin is not in his chain of command. He went to him and said he thought that the language was shocking. All right. But that has nothing to do with how the IA investigations were conducted. It's a fact that has no meaning, if you will.
Well, AR 333 actually encourages someone who believes there's a violation of policy to confront the person who might have violated policy, right?
I don't know if it does that, because usually, I mean, certainly you don't want the victim has no obligation to confront the person that they think has violated policy. And this is where it gets a little muddy, because 4 days later, Commander Minor went to Pop and said he was offended. So Commander Minor is arguably a victim. So there's no HR policy is going to say the victim has an obligation to confront the person that has committed the misconduct.
Okay.
Counsel, how much longer do you have?
Probably an hour.
You try and shorten that up a bit? It seems like we've gone over a lot of this stuff sometimes multiple times.
I feel like it's important for me to be able to cross-examine the witness with at least equal time that the city had.
Well, time's fine, but if you keep asking the same questions and keep getting the same answers, I'm not sure what it is. Keep having to read the documents that's already in the record, what he has reviewed, examined for months. I'm not sure that's helpful, so if you can sort of focus your questions a bit more, it'd be helpful.
Sure. So, is it a significant factor in your mind, the fact that Lieutenant Bonnet was interviewed on the Tuesday after Commander Minor was interviewed on the Friday?
Well, it's significant in the sense that had Lewis known that he was the person who was offended, Lewis would have interviewed him sooner. And because, you know, from Lewis's standpoint, and you have to, he's been directed to conduct this investigation, and he's interviewing people, and everybody's like, no, wasn't offended, I wasn't offended. And so Lewis is getting to the point where he thinks, why am I doing this investigation? Nobody's offended. And then it just was happenstance that he got to Bonnet, and he said he was relieved because finally he found the person who was upset by the comments. That could have been short-circuited
By a day?
if Commander Minor would have disclosed that.
Would that have been short-circuited by one day? Because Sergeant Lewis didn't do any interviews on the weekends in this case, right?
I'd have to look at no, he didn't do any on the weekends, but he was January 2nd, but he interviewed several people before he got to Bonnet.
Okay.
Counsel, again, consider what the purpose of the questions are and whether or not you can argue them based on the documents. Whether the witness thinks something's appropriate or not really may be interfering with the decision of the board. So you could point out, you know, we did this, did that. Her opinion, I'm not sure is that helpful to the board. Maybe it is, or maybe counsel will respond and think she's the expert witness.
I'll end my questioning right now if the board wants to give no weight to her report and opinions on these matters and how they're
I'm not going to
organized.
say that, but I just, you have to decide at what point if that's objected to say that the board has no weight. You have to decide how much is enough. And I'm not sure how much time that's going to take you.
My intention is
You're sort of
to,
nitpicking the report, so continue, but just be aware of that.
I mean, like I said, I'm here for you guys. To the point where, and if I've already accomplished my goal to say that no report or deference will be given to her conclusions, then fine, I'll end right now. If I need to attack her findings and why I think they affect the credibility of those findings and the factual basis for them, I'll continue. I mean,
You're asking her whether that question, you're not arguing it to the board. And I don't think it's appropriate, I will not ask the vice chair whether he thinks he's got enough information to make a determination on whether or not how much weight or report should be given. But just be aware of that. It seems to be you're getting into some cumulative better evidence if your objective is to find out where a report should not be given much credibility. And let the vice chair like to dive in.
Just a point of recollection, clarification, if you will. I'm quite sure that Lieutenant Lewis testified yesterday that he has done interviews on Saturday.
right. In this case, he didn't. And I mean, okay. I'll establish that further, Father. Thank you.
And counsel, just for example, what difference if it was 1 day or 3 days?
Right.
In the scheme of things. So let's get down to the information the board needs that's really important. It seems you're getting down to the very minor things here.
Okay. So
Excuse me, but just before you continue, could I have
I'm
a
sorry,
break?
speak up.
May I have a break at some point, please?
Yes, do you want to take one now?
I don't know how much longer
If
it's
we're getting,
going to take
it's
one.
11:30, I was thinking we could go till lunch and then take a break and do the executive session at one time. I'll tell you, do we have, is lunch here, break for lunch now?
Yes.
Yeah, I've been told that lunch is here. Is anyone interested in taking a lunch break now and then we're going into executive session all at one time? Council respond, is that okay?
No objection, thank you.
Council for appellant, is that okay?
yeah, is there an agenda for the executive session?
No,
There
we have
is.
the right to go into executive session at any time, that's on the.
If you look at the agenda, it has a language in there to go into executive session if needed to get legal advice.
I didn't even know there was a motion to do it. I'm fine with
No,
that.
In order-
I'm going to ask if there was a motion.
Yeah, okay. I'm sorry. It was just a procedural question. That was
And I
it.
was just going to clarify, we do need a motion and a vote.
Right, no, I just wanted to make sure the schedule
Sure.
is okay with it.
Yes.
Okay, so let's do this. I believe there's a motion that's going to be made. Can I give the motion?
I think you asked the question if we should break for lunch.
Right.
I have point of view with that.
Oh, okay, I'm sorry.
That we should finish with this witness, do lunch when she's excused, take a 5-minute break right now for comfort.
Okay, my concern in that regard is he said he had another hour's worth of examination, so we wouldn't be breaking until about 12:30, or we still have to.
Since we're probably going to be here till 7 o'clock tonight,
Oh,
the later lunch is, the better for me.
okay, then maybe that's correct. Okay, then can I have a motion to go into executive session? Do that now, and then while we're in executive session, let's serve that for 15 minutes.
I move that we go into executive session.
Okay, all in favor? Second, all in favor?
Aye.
Say aye. Okay, we will go into executive session until 11:45. During that period, Council, if you could